Morning, everyone. I'm going to call the proceedings of the Judiciary Committee to order, and would you please stand and join me in the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, so I know that we have a lot of people here for HR 41, and in the interest, please understand, you're more than welcome. We're going to have a hearing on that bill. You're more than welcome to stay if you'd like and to testify if you'd like. But what I want you to know and maybe you've heard this from the ranking member already, but if you haven't, the prime sponsor of that bill has asked that the bill be ITL'd, and that is what I can't speak for the committee's vote, but I feel fairly confident that that's exactly what we're going to do. Nonetheless, it is scheduled for a hearing. I know a lot of people have come for the hearing, and if you wish to testify, you're more than, when we open the hearing on that, you'll be more than welcome to testify. But if there are some of you if the fact that it's going to be ITL would change your mind, I didn't want you to have to wait here for nothing if you didn't want to, but that's completely up to you. I'm sorry. Yes, very good point. ITL means inexpedient to legislate. This bill is not going to move forward. So anyway, with that, I'm going to. So with that, I'm going to open the hearing on HB 1611. The prime sponsor is Representative Podolchak, and I don't believe he's here. So Representative Kutab, would you mind introducing the bill? Oh.
Good morning. Thank you, Chairman Lennon, members of the Judiciary Committee. For the record, I'm Representative Keelan Kutab, and I'm here to introduce House Bill 1611 relative to the taking of private property on behalf of the prime sponsor, and I will not be taking any questions. Thank you.
Thank you. Is there anyone else here who wishes to be heard on House Bill 1611? Seeing none, I'm going to close the hearing on House Bill 1611. And I would now like to open the hearing. Oh, I'm sorry, I can't. Yep, I can't do that. All right. So if we could, yes. So I'm going to, no, I know. So what I would propose to do is open an executive session on House Bill 1611. And the first thing I would say before I don't entertain any motions or anything like that, is just the prime sponsor is not here. I have had no discussions with anyone about why this bill is necessary. And I guess I have a question for the committee. Has anyone had any discussions with anyone about this bill, like why this bill is necessary, why we need it, anything like that? Chair recognizes Representative Birch.
Thank you. I would move ITL.
Is there a second?
I'd second it.
All right. Representative Birch, do you wish to speak to your motion?
Only that I think this bill is unnecessary. There already are procedures in place. Nothing has been shown that those procedures haven't worked, and I'm concerned about adding complexity to an emergency circumstance is not well thought out. Thank you.
All right. Anyone else wish to be heard on this? I think it's somewhat unfortunate that we don't have someone here presumably there was some thought that this was needed. And so I'm puzzled, but in the absence of some explanation of why it's needed, I think Representative Birch makes very good points. So with that, anyone else? And so I intend to vote ITL also. Anyone else wish to be heard? Representative Scully.
Yeah, thank you, Mr. Chair. And again, quickly, I think it's vitally important that demonstrated need be demonstrated, for a bill. And since we don't have that need shown clearly, I wish the sponsor would be able to show up to talk about this. When in doubt, I vote no on things. So it's going to be, I will vote ITL.
Anyone else wish to be heard?
Yeah.
Yes, Representative Horde.
Well, just looking at line 3, the current law that it's amending, which I'm not an expert on, but it says, currently it says this section shall not apply to personal property owned by or intended for use by individuals and families. So that's basically trying to prevent the state from seizing just people's personal property, the furnishings in their house, their clothes, their so forth. And then he's adding real estate or real estate improvements. So that's a very broad expansion of it. So I would probably be inclined to ITL this, even if I knew exactly what the goal of this legislation is. And so it's a pretty, they're proposing a pretty major change. So that's another reason to ITL, aside from the simple fact that, like, they're not here to explain why this is needed. So,
All right. Anyone else wish to be heard? All right, seeing no one, I would ask the clerk then to call the roll. It's on the motion of Representative Birch, seconded by Representative Manos. The motion is to ITL the bill.
Vice Chair Mannion,
yes.
Rep Tripp,
Yes.
Rep Andrews,
Yes.
clerk votes yes. Rep Scully,
Yes.
Rep Ball,
Yes.
Rep Birch,
Yes.
Rep Smith, Rep Horrigan,
Yes.
Rep Davis,
Yes.
Rep Manos,
Yes.
Rep Tur,
Yes.
Rep Rung,
Yes.
Rep Bergeron,
Yes.
Chairman Lynn,
Yes.
15 yeas, 0 nays.
Anyone object to it going on consent? Seeing none, it'll go on consent. And Representative Birch, will you write the report?
Yes.
Thank you. All right. Let me see, is there anything else we can, I think we need to talk, we need to talk before we can. Yeah, so, all right, so, we have about 15 minutes before we can open the hearing on HR 41. So I'm going to recess the committee and ask my colleagues in the Republican caucus to join me and then across the hall so we can discuss some other bills that we have to exec today. Thank you. Uh, excuse me, I'm going to open the proceedings of the Judiciary Committee again and open the hearing on HR 41, and Chair recognizes Representative Mann.
Thank you, Mr. Chair, members of the Judiciary Committee. Representative Dennis Mannion, Rockingham 25 Salem. I am going to introduce this bill for the prime sponsor who could not be here today. So I'm going to introduce HR 41, instructing the House of Representatives to investigate whether grounds exist to impeach Executive Counselor Karen Layout Hill. And then we'll be taking any questions.
All right, thank you. All right, any questions? Oh, well, he's not taking any questions. So, all right, next is, all right. So, as I understand, Executive Counselor Hill wishes to be heard, and please come up.
Thank you so much. Good morning, members of the House Judiciary Committee. Based on the information that was provided earlier indicating that Representative Sweeney has asked the committee to ITL this bill, I will keep my testimony very brief. And I also will have asked the other folks who have offered to testify on my behalf to forego those comments today. We know that you have a lot of business and we don't want to take up too much of your time. I very much appreciate the opportunity to be heard. And I thank very much all of the members of the public who are here today supporting me, as well as the nearly 2,000 people who have signed in opposition to HR 41 online. I have submitted materials, including the Attorney General's report, as well as the right to know request with the emails that were in question regarding this resolution. So those, I would ask that those be made part of the public record. I also submitted a memo. And so in short, to summarize, my emails were typical constituent services. The Attorney General found no wrongdoing. Given that there was no misconduct in this case, the House Judiciary Committee should send HR 41 to the House with a recommendation of ITL. And I appreciate that it sounds as though everyone is in unanimous support of that position. And so thank you very much, representatives.
Thank you. Any questions for Representative Horrigan?
This is more of a pretty obvious rhetorical question, but is not your term just 2 years like that of the governor and every member of the legislature? So one of the reasons, and isn't that probably historically why there have been so few impeachments, because all the elected officials have 2-year terms here in New Hampshire, so the people will be able to decide one way or the other how they feel about you, in a few months in November. Is that correct? Yep.
That is correct. Impeachment has historically only taken place on 2 occasions, both regarding judicial conduct. And in fact, in one of those cases back in 1790, that judge decided to resign before the trial took place. And impeachment has never taken place in New Hampshire against an elected official. And I do believe that that is because in New Hampshire, we have 2-year terms for members of the executive and legislative branch. And the voters are the ones who hold their elected officials accountable. Thank you.
Any other questions? Yes, Representative Farland and then Representative Brunch.
Thank you, Mr. Chairman. Would you believe that using government email to perform constituent services is wholly appropriate for your office or for any office elected by the people?
I would believe that. Thank you. And as a city councilor for 20 years, I used my official email at times, many times, for constituent services. And over the last year, I've used my executive council email to provide constituent services. As I know, members of the legislature often are serving we have constituents in common. And I know that many folks, elected officials, use their official emails for that purpose. And it is well respected and I think an important part of our jobs.
Thank you.
Sorry, Representative? Yes.
Thank you, Mr. Chair, and thank you for taking my question. I know that the prime sponsor isn't here to introduce this resolution, and considering also that the Attorney General has found no wrongdoing, could you just describe what the impact of this has had on you as far as time, resources that you've had expended on this?
Well, thank you for that question. That is a good question. I would say that I think I've been able to continue doing my job as an executive counselor despite um, this initiative. It certainly has taken some of my time and focus away from other things that I would have liked to do. And I have had to expend some, I've had to hire an attorney and make sure that I can respond reasonably to these charges and to defend myself. I think the sooner that we can dispose of this, the better it will be for all of us, because I don't think it's a good use of any of our time. There are a lot of other priorities that the people of New Hampshire expect us to be working on.
Any other questions for this witness? Seeing none, thank you very much. All right, anyone else who wishes to be heard on HR 41? I have two pink cards here, but in light of what is going to be the result here, you certainly don't have to testify. But anyone else? Anyone who? Yes. Can you just tell us who you are, please, sir?
Yes, my name's Avery Sear. I live at 30 Hanover Street in Manchester. I'm the moderator for Ward 3, which is the downtown area of Manchester, and I just wanted to briefly say that the people of Ward 3 would not be in favor of this bill. They want progressive politicians, and they do not want to see Miss Karen Hill get impeached, so I'm against this. Well, people of Ward 3 are against this resolution.
All right. Any questions for this witness? Seeing none, thank you. Anyone else who wishes to be? Yes. Have you filled out a pink card, sir?
Yes, my name is Kennard Sullivan, and I reside in Londonderry, New Hampshire. And
I don't think we do have the card. I mean, go ahead. You can testify, but I'm going to ask you to please fill out the card.
Yeah, I think I left it on the.
No, we don't. We don't have it.
All right, I'll fill it in. Oh, okay.
Yeah, just when you're done testifying, if you just give it to me.
Okay,
I appreciate it.
for sure. Yeah, I just wanted to, as an observer of this, there's a term that I came across in researching this lawfare, and I think it's worthy of spending just a few minutes on that. Lawfare is using a legal system to damage or delegitimize an opponent. It's frequently described as a high-profile litigation between political parties. It's an abuse of power, it's a violation of the rule of law, and it's a form of political persecution. It's really what we call malice, and can be thought of as malice aforethought. That's malice ahead of the time. There's an international and historical context. Lawfare has been used quite effectively in Nazi Germany, Russia, Turkey, and Hungary in recent times. And it's used to consolidate power and suppress dissent. And in America, we thrive on having a healthy dissent to make the political system work. Lawfare does not preserve civil liberties. And as I said, it's an abuse of power, a waste of taxpayer resources, legal fees and so forth. And it's politically motivated. It's a weaponization, and at its core, it's a violation of constitutional rights. We need our judicial system to be independent and not be holding to the political side of things. So we can't have individuals being targeted by government officials. The recent Supreme Court has ruled on this and recognized that government officials cannot arrest political opponents without consequences. The US Congress has passed the NOPE Act, No Political Enemies Act, and it was actually spearheaded by the Republicans. So whether you're Republican, Democrat, or independent, this applies to everyone. So at its core, this is a method of usurping the democratic process. In New Hampshire, at least the town that I'm from, Londonderry, we've always had a good rapport between the political parties. We debate, we discuss things, and then we agree to disagree, but we still remain friends. So I just view this as an erosion of the overall public trust, and it's a policy that really doesn't belong in New Hampshire. So with that, I just wanted to get some of those thoughts out there, just, as they say, food for thought.
Thank you. Questions for this witness? Seeing none, thank you very much, sir. Anyone else who wishes to be heard on HR 41? All right, seeing none, I'm going to close the hearing on HR 41, and I'm going to open an executive session on HR 41, and the chair recognizes Representative Birch for a motion.
Thank you, Mr. Chair. I move ITL.
I'm going to second that motion. Anyone, Representative Birch or anyone else wish to be heard? Representative McFarland.
Thank you, Mr. Chairman. I think it is appropriate just to state for the record that lawfare has to do with judicial activities and not with legislation. And furthermore, New Hampshire has a long history of having public hearings on all bills, however daft they may be. Thank you.
Other comments? Anyone else wish to be heard? All right, so I guess we're ready to call the roll on HR 41, moved by Representative Birch, seconded by myself. The motion is ITL.
Vice Chair Mannion,
Yes.
Rep. Gagny, sorry,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes yes, Rep. McFarland,
Yes.
Rep. Scully,
Yes,
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. Davis,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rung,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes,
17-0.
17-0, ITL. And anyone object to this going on consent? All right, it will be on consent. All right, and Representative Birch, you draw the honors of the report, if you would, please. All right, I'm going to close the executive session on HR 41, and I guess I just want to say to Executive Counselor Hill and to all the other people here, I'm really sorry for the late. This happened, so to speak, so late in this process. You're all here. I know your time is valuable, and I'm sorry that you all. I mean, we're glad you're here, but we're sorry that you had to come for essentially for sort of a foregone conclusion. So thank you all very much. All right. All right. Committee in recess for a minute before we go on to other executive session matters, because we need to caucus again, and maybe
So it's not a minute.
it's not a minute, and maybe my colleagues on the other side also need to caucus. All right, I'm going to call the Judiciary Committee back to order and open an executive session on House Bill 1384. And the Chair recognizes Representative Kutab for a motion.
Thank you, Chairman. I move ought to pass.
All right, and is there a second to that?
I second.
All right, moved by Representative Kutab, seconded by Representative Ball. And do you also have an amendment?
I
Representative
do.
Kutab?
I wish to move Amendment 2026-0921H.
Is there a second to that?
Second.
All right, so moved by Representative Kutab, seconded by Representative Ball. Representative Kutab, do you wish to speak to the amendment?
Very briefly. So what this amendment does is it prohibits foreign entities of concern from financing third-party litigation. And the foreign adversaries of concern are what's on the federal list under 15 CFR 791.4. That's all this is doing. The rest of the pieces of the bill have been removed.
All right. Anyone else wish to be heard on 1384? Yes. Representative Birch.
Thank you, Mr. Chair. There's much that I like about this bill, but what concerns me is how it would work in real life. If we were concerned with the original bill in terms of having one side have to submit to disclosure requirements unbalanced by the other side, that was a problem I think that was widely recognized. Here we have a situation where there's a ban on financing lawyers in certain kinds of litigation recognized by the federal government bad guys, countries. I get that. What I don't understand, and perhaps the sponsor can explain, is how it would work without every time a company is defending or prosecuting a suit having to disclose who their funders are to determine whether there's a potential violation of law. So if a public interest group sues a corporation, let's say, they can't have that suit funded by foreign bad entities. But how would you know unless the defendant had a chance to go through the financing of the lawsuit to find out? And that recreates the whole problem in the original bill. So if there's a way that one side doesn't have to undress just to show they're in violation of the law, I'd like to hear.
Anyone else? Representative Kutab or anyone else wish to be heard?
Thank you. So this is no longer requiring the in-camera review that the original bill required an in-camera review. I think it's one of those things where if there was a question, if they were illegally doing something, the judge could do an in-camera review, but it wouldn't require it to be done every time. I think that that's going to take up an unnecessary amount of judges' time to just have to go through and review every single one of these for no reason. But if there was a question, if this law had in fact been violated, the judge could easily, call for an in-camera review of it. And attorneys in our state are all licensed and barred. I just don't see them moving forward with something that could potentially jeopardize their bar license, knowing that they're not allowed to do it.
Chair? Yes.
Unless I read it wrong, there is no provision here for in-camera review. So what I'm concerned about is a standard practice then of one side to ask by way of discovery or deposition, please disclose your funders so that I can determine whether you have, you're in violation of such and such statute. And there seems to be no protection against that. So I would expect such a motion might be filed in every single case. And that's my concern with the bill.
Anyone else wish to be heard? Representative Horton.
I mean, as far as entities are concerned, it's a longstanding federal law, but there is one problem with it is, well, the list is somewhat variable, like Venezuela's on it, but specifically the Maduro regime. So not that Venezuela is probably financing many lawsuits here, but certainly China is has the only economy in the world I think is either as large as ours or slightly larger, and it's certainly their leadership is dictatorial and not somebody we want to do business with, but it's far from a monolithic entity. So there probably could be reasons where individuals or companies that are under the jurisdiction of the government of China, or also like Russia or Iran, or two others, where there might be individuals or companies that disagree with their own government who, for whatever reason, are involved in, have an interest in litigation here in New Hampshire. So that's just a potential problem with the bill. And of course, as a member from Westmoreland pointed out, we could probably have a situation where like litigants here in New Hampshire have to prove, or going to be asked to prove that they weren't involved with these foreign entities of concern, regardless of whether there's any credible information that they actually are involved with those entities of concern. So that's probably so I think I have problems with this with amendment, at least without having had much time to think about it. I have serious doubts about it.
All right, anyone else wish to be heard? So I guess I would just briefly, I would say, I think in response to what Representative Birch said, I think that in the scenario he posits, somebody on the other side of the litigation sends an interrogatory or request for discovery or something saying, tell us who you're financing the litigation. It would seem to me that would be a perfectly proper response that the attorney on the other side would say is, we have no obligation to provide that information except to the extent that we were being financed by a prohibited foreign party, and we are not, period. And that's the end of the interrogatory, and that would be a perfectly acceptable answer. And unless the party on the other side had some basis to say, well, wait a minute, you're lying about that, you really are being funded by, in which case they could ask for further relief. But I think that would be the way it would be handled. All right, anyone else wish to be heard? All right, I think we're ready for a vote. In light of what seems like this is going to be contentious, I will have a roll call vote on the amendment first. So the motion is ought to pass the amendment 2026-0921H. But I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
No.
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rung,
No.
Rep. Bergeron,
No.
Chairman Lind.
Yes.
Motion passes 9-8.
All right. Now we're on to the main motion, and the chair recognizes Representative Kuta.
I move OTPA.
Is there a second?
Yes, I second.
Right.
Thank you.
OTPA motion moved by Representative Kutab, seconded by Representative Ball. Anyone else wish to be heard before we vote? Seeing none, I would ask the clerk to call the roll, please. The motion is OTPA.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rung,
No.
Rep. Bergeron, Chairman Lind.
Yes.
Motion passes 9-8.
All right. Representative Kutab, will you do the honors of the majority report?
I'd be happy to.
All right. And who will do the minority? Representative Smith. All right.
What will be their
And what will
motion?
be, that would be ITL? Okay. Okay. All right. All right, I'm going to close the executive session on House Bill 1384, and I'm going to open the executive session on House Bill 1389. The chair recognizes Representative McFarland for a motion.
I move ITL.
Is there a second?
I second the motion.
All right, motion's been made by Representative McFarland, second by Representative Andrus. Representative McFarland, do you wish to speak to your motion? You don't have to, but you can.
I'll speak briefly. I would say that the definition in the bill is far too broad. The definitions in statute of PFAS facility are encompassing broadly. The bill has strict liability and retroactive exposure, so ex post facto type concerns, and it's using a federal set of closure rules, RCRA, which are designed for regulated hazardous waste facilities. They're not designed for small businesses or legacy properties. And the threshold is significantly lower than prior bills on this topic. And while it's a lot higher than the threshold for drinking water, it is not at all a high level when it comes to examining soils and buildings and so forth. So I think net overbroad, and it would be significantly destabilizing to certain businesses and properties, and potentially even residential properties. Thank you.
All right, anyone else wish to be heard? Yes, Representative Run.
Thank you, Mr. Chair. I'm going to be against the ITL because there is an amendment that I thought was discussed at the public hearing. It corrects a drafting error that is in the original bill. And I don't know if anyone has that amendment at their place, but it is 0855H. And so it corrects a drafting error, but really the essence of this bill is just to add to current statute any PFAS contamination that exists around buildings, equipment, other types of infrastructure that isn't part of the operations. And to give you a specific example, Saint-Gobain closed their operations in Merrimack, but what they left behind is highly contaminated. In fact, the concrete pad that their plant was built upon is saturated with PFOA. And this bill clarifies their liability for ensuring that that PFAS gets cleaned up. And it's this bill passed the House and Senate last term. It was vetoed by the governor for having that low threshold, which has been increased in this bill to 500 parts per trillion. This is something that's been reviewed by DES. They have not objected to this at all. I believe they were here for the public hearing to speak on it and to address any issues. So I think it's really important. I know it's vitally important for people in southern New Hampshire who have had significant groundwater contamination from PFAS. And until we can address this infrastructure and the pipes and all the stuff that's left behind, that equipment is still going to be contaminating groundwater. And that we do not have a clear statute that assigns that liability to the entity that created it. So that's why I'm going to be voting against the ITL and hope that this amendment can be introduced along with an OTPA motion. Thank you.
Anyone else wish to be heard? Representative
Just a
McFarland.
quick follow-up, Mr. Chair. I would ask for your confirmation. My understanding is we cannot ITL a bill with an amendment. Is that correct?
So we cannot ITL?
We cannot move the amendment as part of the ITL.
Right.
And as such, given that the amendment does not fix any of the concerns I outlined, I think that the amendment is similarly problematic.
All right, so, again, oops, I'm sorry, Representative Birch.
Thank you, Mr. Chair. I listened carefully to the objections from my colleague, and I don't think they're well placed for a problem that exists And to say that the amendment is somehow retrospective when it will address future and past problems that are currently worked on, I think is, doesn't recognize the problem as it is. I mean, ultimately, we're all here to make the Granite State a better place. We have a terrible situation. The legislature has worked well in the past on the PFAS situation, and that affects all of our citizens. The kidney cancer rate is just horrible, and these are long-term problems, and they're not going away. And we've been willing as a legislature to work on it and work on it. Science moves forward. And to say that this is a higher, I don't know whether the word is higher or lower, but a different level of limitation on PFAS and PFAS type things is simply a recognition that science changes. And what science tells us this year may be different than what it told us 3 years ago or 5 years ago. And I don't know who this bill harms other than saying that the people who caused this massive harm to our neighbors and our neighbors' children need to be responsible in the fullest honorable way to take care of it, and that we need to be sure that this kind of problem doesn't happen in the future. And to the extent that we're here to help our neighbors and help our land become as clean as it should be, then I personally would urge every single person on this committee to vote for the bill as presented and vote against the ITL.
Anyone else wish to be heard? So I guess I just, oh, I'm sorry, Representative Scully. No, it's all right.
All right, thank you. Representative Birch, I think your wish that we take care of problems going forward is what I share with you. But this is not about problems going forward. This is a retroactive bill. It's ex post facto, I think is the legal term, where you're trying to, or the, not you, the bill is trying to put additional penalties and punishments on people for something that's already happened. If this was a bill that would deal with this issue going forward, I would have no problem with that. But I'm always against the idea that we can go back and punish people for additionally for things that, when we didn't have those laws in the books at the time. So for that reason, I'll be voting RTL.
So I guess what I would say is, I mean, I really, you, Representative Scully, you've kind of summed up exactly what I was going to say. I mean, I think if I understood, if I take Representative Rung at her word, that I think what she said is this bill would establish liability for the past acts where liability under current law is not really clear. That to me is the essence of a retrospective law. It's saying you did something that you may not have been liable for before, but now we're going to, even though you've already done it, we're now going to make you liable for it. I have a hard time understanding how that's not retrospective. And that's one of among many other things that including the other points that Representative McFarland made that lead me to conclude that I cannot support this bill. Anyone else wish to be heard? All right, I guess we're ready for a vote. The motion is ITL, and I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes,
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
No.
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rung,
No.
Rep. Bergeron,
No.
Chairman Lind.
Yes.
Motion passes 9-8.
9, 8, Yeah, all right. Representative McFarland, can I call on you to write the report for the majority?
Yes.
All right. And who will write the minority?
I'll cover it. And eventually, Representative Page will
Okay,
further, but I'll.
all right. And that, I assume, would be OTP A. Is that correct? All right, minority.
Is there an amendment?
OTP. Yeah.
Yes, the amendment number is, 08558.
I know, yeah, somewhere I do too. All right, I'm gonna close the executive session on HB 1389, and I'm gonna open the executive session on HB 1416. The chair recognizes Representative Scully for a motion.
Thank you. I move that we OTP A. Is it, do we
Right,
OTP
and
first?
I
then talk about-
I understand you have an amendment you'd like to introduce.
That is correct.
All right,
Does everybody have a copy of the amendment that I have proposed? The amendment itself, I think, is quite simple, but
and remember you're talking about it's 2026-0916H, is that correct?
thank you, Mr. Chair. That is indeed correct.
Oh, I'm sorry. Is there a second
Nice,
on the, on Representative Scully's motion?
Yes.
All right. Seconded by Representative McFarland.
All right.
Representative Scully.
Thank you again, Mr. Chair. So, I mean, we heard the testimony regarding this bill, and I think one of the main objections to it, and I think it was a reasonable objection, was the idea that well-meaning but unqualified people might be giving out medical advice to folks who are seeking help and services. So this is a simple replace all for one of the provisions of the bill that, in my mind, is worded in such a way that it will make sure that only qualified medical personnel are giving out advice to people who are pregnant or, folks significantly involved in that. And that if that particular facility cannot provide those services themselves, that they are also allowed to refer those people to qualified medical personnel so they get the correct level of care.
All right. Anyone else wish to be heard on the amendment? Oh, yes, Representative Smith.
Thank you. If I could just ask my colleague a question. I've read this amendment several times, and I'm having a problem. Two problems. The first is the use of the word medical, where sometimes in the bill we use medical and sometimes not. But this says prohibit a medical pregnancy resource center from providing any pregnancy-related care or treatment, including by a qualified medical person. So this is saying you're prohibiting a qualified, unless I'm missing something. It seems to me it's saying you're prohibiting a qualified medical person from providing these services.
It read in and of by itself, you're correct. It would read that way, but understand this is a replacement of an existing portion of the base bill. And if you go back and look at the base bill, it says the state, shall not. And then it listed all the things that they shall not do. So in that case, this is one of the things that they shall not do.
Thank you.
Yes, Representative Manos.
Thank you, Mr. Chair. I also have two concerns. It says may reverse the effects of chemical abortion drugs. And as we heard, abortion pill reversal is unproven. It's not peer reviewed, and it's not medically accurate information. So I cannot support this for that reason. But in addition, I would like to ask my colleague, the sponsor of the bill. It says that in the last sentence, a portion of it, referring a client to such qualified medical personnel for such treatment. That would imply to me, and I asked my colleague, an outside referral could be, and I personally would want it to be, to a medical personnel who would provide informed consent and therefore be required to provide a patient with all options for their care, including abortion. And that's how I would read this, but knowing your position, I would doubt that's your intention, and so I would like clarification on that. Thank you.
May I respond?
You may respond,
All right,
sure.
thank you. Well, regarding the issue of the abortion pill reversal, given that we are referring people to a qualified medical person regarding these issues, I assume if they will be getting the proper advice from a qualified person, whether this could even be possible or not, or danger. Again, I think by sending, I will say, I am not an expert in this area. I just want to make sure the right person who has the proper training is being consulted regarding any issue regarding, health issues in pregnancy. And the same would hold true. Now we're getting back, I don't want to start getting into compelled speech in terms of telling qualified medical personnel what they must do. I'm assuming, again, if we're putting people in front of the right people, they will discuss all options. I will leave that up to them. I don't feel like we should actually be telling them they have to do that. Let's leave the qualified medical personnel, give them the best advice that they can.
All right, anyone else wish to be heard on this? All right. So I guess the only thing I would say on the amendment is I have some qualms, as I've told my colleagues, about the underlying bill, but I certainly agree that this amendment makes the underlying bill better than it was without the amendment. So on the amendment, I intend to vote in favor of the amendment. All right, anyone else wish to be heard? All right, seeing none, then on the amendment, I would ask the clerk to call the roll, and it's amendment 2026-0916H.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
No.
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Tur,
No.
Rep. Rung,
No.
Rep. Bergeron,
No.
Rep. Lynn.
Yes.
Amendment passes 9-8.
All right, now we're on to the main motion, and again, the chair recognizes Representative Scully.
Thank you, Mr. Chair. I move OTPA on House Bill 1460.
All
I
right,
second.
all right. And it's moved by Representative Scully, seconded by Representative McFarland. Anyone wish to be heard on the main motion of OTPA? Yes. First Representative Scully, then Representative Horry.
Thank you again, Mr. Chair. I think that most people, or a lot of folks on this issue of abortion, will say that they are pro-choice, and I can respect that. I think what we're trying to do is protect the people who are actually giving the pregnant women a choice, and therefore I think this bill should be passed.
All right, Representative Horry.
Yes, we specifically heard a lot. They're trying to prevent New Hampshire from passing a law like the one in Vermont, and we had I'm still opposed to the bill. We had some very compelling testimony by a woman from Keene. I believe her name was Jean Marie Davis, and her story is even told on the front page of the Union Leader, who runs a pregnancy resource center in Brattleboro, just a few miles from Keene. One thing about the Vermont law, it may have been overly broad. It was the subject of a federal lawsuit, and actually one of the things that happened, well, first of all, the lawsuit, which was brought by basically a National Lobbying Group for Pregnancy Resource Centers. That lawsuit, first of all, was dismissed in 2025. Then also in 2025, the Vermont State Legislature actually amended the law that was the subject of the lawsuit and basically met all the objections that were brought by the lobbyists for the Pregnancy Resource Center. So they actually still have a law in the books, which is about health, basically, I guess it's about health centers in general. And so I think if our concern is that we don't want a law like the one in Vermont, they actually changed the law like the one in Vermont. And also if the supporters of this bill want these centers to be unregulated, they probably, my opinion, they probably are like better off with the status quo where they're not regulated in New Hampshire law at all. And certainly putting this new RSA 322.0, I believe it is, that puts something in the law books which future legislatures can amend. I mean, I've personally often thought there should be some sort of regulation, but I haven't really been sure what or how. So like you're actually probably increasing the chances that some future legislature might want to place some restrictions on these operations because now you have a place in the RSA specifically to put such regulations. So I personally think the best thing to do, regardless of how you feel about your issue, and I know there's a wide range of opinions, is probably not put another RSA into the bill and let's leave the status quo for the time being. And then, and obviously this issue will be debated in the future, but I think right now this bill is unnecessary. Aside from being a bad bill, it's also unnecessary because the goal of the sponsors has already been met. The status quo is the fact that these centers are not regulated at all. So I probably urge, anyway, so that's why I'm voting ITL. And I think even those who are sympathetic to the game this bill, I think probably their best option is to vote ITL. Obviously, I can't speak for anyone but myself. So thanks.
Anyone else wish to be heard? So I guess what I would say on this is, it seems to me that one of the strongest arguments that I have heard against this bill is that it's just not necessary. Now I have to say, the fact that all the witnesses that showed up to testify about killing it would makes you have some suspicion as to what they would like the law to be. But it's right now. I think I agree with Representative Horrigan that there is no law that's preventing this. But I also think on the other side of this, my recollection is that when last year there was a bill to put in statute a law saying that abortion at less than 20 weeks was legal, to affirmatively state that. Those of us who voted against that bill said it was not necessary because nobody's trying to stop abortions of less than 20 weeks. The law says that it are only prohibited. At 24 weeks. The law says it's only prohibited after 24 weeks, and yet my friends on the other side of the aisle here all voted to support that. It seems to me that that's sort of the equivalent from the other side of what the proponents of this bill want to do now with this bill. And I didn't support, I voted no on the bill to state positively that abortion less than 24 weeks is legal because I didn't think it was necessary. And I'm going to vote against the OTPA because I don't think this is necessary either. Representative McFarland.
Thank you, Mr. Chairman. And I think to your point, I do not recognize this bill as being in any way an abortion bill. It is a bill that is protecting these existing pregnancy resource centers, and we have indeed heard current testimony that is compelling that institutions and agencies elsewhere have tried to shut these down, and for those reasons I will be voting in favor of this motion.
Anyone else wish to be heard? All right, seeing none, so now the motion before us is OTPA on House Bill 1416, and I would ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes yes. Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
No.
Rep. Smith. Rep. Horrigan.
No.
Rep. Davis.
No.
Rep. Manos.
No.
Rep. Tur.
No.
Rep. Rung.
No.
Rep. Bergeron.
No.
Chairman Lind.
No.
Motion fails 8-9.
All right, is there another motion? Chair recognizes Representative Manos.
Thank you, Mr. Chair. I would move ITL. And I would reemphasize your point.
All right, first, we have a second.
Oh, I'm sorry, excuse me.
So moved by, ITL motion is moved by Representative Manos, seconded by Representative Birch. All right, and Representative Manos, you wish to speak to your motion?
Thank you. Just briefly, I would reemphasize your point, Mr. Chair, that this bill is drafted to address a hypothetical problem in New Hampshire. We heard clearly in testimony that there have been no legislative attacks on crisis pregnancy centers in New Hampshire. Therefore, this bill is unnecessary. And in addition to that, it's harmful to patients. And therefore, I support the motion of ITL. Thank you.
Anyone else wish to be heard? All right, so the motion before us now is moved by Representative Manos, seconded by Representative Birch, ITL on House Bill 1416, and I would ask the clerk to call the roll, please.
Vice Chair Mannion,
No.
Rep. Gagne,
No.
Rep. Tripp,
No.
Rep. Andrews,
No.
clerk votes no. Rep. McFarland.
No.
Rep. Scully.
No.
Rep. Ball.
No.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Davis.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rung.
Yes.
Rep. Bergeron.
No.
Chairman Lind.
Yes.
Um, 8-9.
So the ITL fails also.
I move that we submit the report without recommendation. With respect, there's a motion on the table. Mr. Chairman, there's a motion on the table.
But we're not leaving the room, so if you want to have a discussion with anyone, please do that.
Mr. Chairman, with respect, isn't there a motion on the table? I move to submit without recommendation.
No, I'm not going to do that. So the chair understands that Representative Bergeron wishes to be heard? Yes.
I would like to reverse my vote on the last one.
So my recollection is that your vote on the ITL motion was no.
Correct.
Am I understanding you wish to change that to yes?
Correct.
So you,
Got to move to reconsider because we already called the vote. So we have to move to reconsider and vote all over again.
the chair recognizes Representative Birch.
I would move to reconsider.
Is there a second? Seconded by Representative Mann.
Point of order, Mr. Chair.
Yeah,
I thought the reconsideration needed to be put forward by somebody on the prevailing
not in
side.
the
Not in
committee. I
committee.
specifically asked, talked to the chair, to the clerk about that now.
Thank you.
Doesn't have to be. All right, so it's been moved and seconded to reconsider the vote. Anyone wish to be heard on that? Representative Manos,
Seconded.
seconded, right, all right. All right, so, we're gonna, motion before us then is to whether we should reconsider. So,
We could do that first.
you want to do that by a show of hands? Right. So all those in favor of reconsidering the vote, please raise your hand. Ten. All right, so 10. All those opposed to reconsidering, raise your hand. Is that right? 10 to 7. 1,
Yep.
2, 3, 4. All right, 10 to 7. So the motion to reconsider is granted.
Chair, could I just
Yeah.
ask a question? Frequently, well, not too frequently, I hope, we have occasion to reconsider a vote in a committee. And often it is because one of our colleagues was confused about something. And here and also on the floor, we tend to respect our colleagues' confusion and without regard to how we voted initially, vote to permit reconsideration. And I just want to make that comment for people to think about why they would agree or not agree to reconsider. Thank you.
Thank you. Second. All right, so the motion to reconsider passes on a vote of 10 to 7. And we're now back to the motion is the motion is ITL, moved by Representative Manos, seconded by Representative Birch.
The motion needs to be remade. So let them remake.
Okay, all right, so chair recognizes Representative Manos.
Thank you, Mr. Chair. I would move ITL.
There's a second. Representative Birch. All right, moved by Representative Manos, seconded by Representative Birch. The motion is ITL. Anybody else wish to be heard on the motion? All right, so I'd ask the clerk to call the roll.
Vice Chair Mannion,
No.
Rep Gagny,
No.
Rep Tripp,
No.
Rep Andrews. No. Clerk votes no. Rep McFarland,
No.
Rep Scully,
No.
Rep Ball,
No.
Rep Birch,
Yes.
Rep Smith, Rep Horrigan,
Yes.
Rep Page, I'm sorry, Rep Davis,
Yes.
Rep Manos,
Yes.
Rep Tur,
Yes.
Rep Rung,
Yes.
Rep Bergeron,
Yes.
Chairman Lynn.
Yes.
Motion passes 9 to 8.
All right, so, motion, ITL passes, 9 to 8. Representative Manos, will you write the majority report? Majority, and who's gonna write the minority report?
Mr. Chair, I'll be willing to do that.
Okay, all right. Minority. And that would be OTPA, is that correct?
Absolutely correct.
Okay. All right, I'm going to close the executive session on House Bill 1416, and I'm going to open the executive session on House Bill 1419, and the chair recognizes Representative McFarland for a motion.
Thank you, Mr. Chairman. I move OTP, and I will also seek to move an amendment.
Yes, well, first, is there a second on the motion?
I second.
Second by Representative Cobb, now on your amendment.
Yes, I'm going to move amendment 2026-0897H.
Is there a second for that?
I second.
All right, moved on the amendment by Representative McFarland, second by Representative Katab. Representative McFarland, do you wish to speak to the amendment?
I think we've largely addressed both the bill and the amendment in the hearing, but I will say that the amendment is simply to make sure that the commission terminates at the end of 2027 with its final report and takes care of self-repealing and putting all this to bed. So that's the reason for the amendment. And I think to save time later, I'll just say if we're serious about economic growth, legal excellence, and long-term revenue without broad-based taxes, then we should let this commission do its work.
Anyone else wish to be heard on the amendment? Representative Smith.
Thank you. I'd like to ask my colleague if he has had any conversations with any members of the Senate, because the Senate has, as a rule, opposed the establishment of commissions.
Yeah, thank you. I can tell you that I have spoken with several members of the other body, and I have received some favorable indications, including from senior members of that other body.
Representative Birch, do you wish to be heard?
Yes, and my question, I'm not sure whether it goes to the chair or the sponsor. I'm curious what happens on a commission that has members of the legislature on it, stacked on one side perhaps, but members of the legislature on it. And there's an election coming up, and in the middle of the work of the commission, those members, some of those members perhaps who are members of the commission are not returned to office. Does that make any sense, having this bill at the tail end of the second year as opposed to perhaps reintroducing it in the first part of next year?
So I'll say two things, if I may respond, Mr.
Yes,
Chairman.
of course.
I'll say two things to that. I think, first of all, when I had originally drafted this, I had proposed a longer period for the commission to do its work. And I think that in conversation with several parties, including members here, we concluded that it was both practical and appropriate to report earlier. And I think as far as should we defer this to a later session, I would say to you that other states are already acting, have been acting, and we should act timely on this in order to retain and potentially gain advantage here. So I think for the interest of New Hampshire, it doesn't make sense to defer it. And I mean, I think it would be folly for us to represent this as or act on it as if it were a partisan bill. It very much is not. It is very much intended to be a bill that is simply a non-partisan effort to advance the interests of New Hampshire and New Hampshire business.
Anyone else wish to be heard? Representative Smith.
Thank you. In the executive session, I'd like to direct my comments to my good friend. First of all, one of the problems with a commission that by definition involves people other than legislators is that it takes a very long time for other organizations to identify the individuals they want to represent their interests. Sometimes it takes 6 or 8 months. And that's one of the reasons that commissions, in the way the New Hampshire legislature functions, are not particularly helpful. In response to Representative Birch's question, which I don't think has been answered, any member appointed from the House or the Senate who is not reelected would lose that particular position and then would have to be replaced by someone else. I haven't seen any fiscal note on this, and I imagine that people in support see millions of dollars rolling in. And that would be wonderful because there's a lot that we ought to be spending money on. Why aren't you proposing, instead of a commission, the formation of this new entity so that we could get ahead of other states?
May I respond, Mr. Chairman?
Yes.
Thank you. So I think to your points, first of all, were there to be people appointed who did not, as you say, win in November and they were no longer able to serve through dint of two A or B, there is still 2H, which provides for an additional 3 members up to, it could be 0, appointed jointly by the Speaker of the House and the President of the Senate. So continuity could be established in that way. I think to your point about the time it takes to assemble the commission, you're absolutely right. And I think it's a balancing act here to consider what makes sense. Ultimately, if there is an inability to perform this reporting timely, we can always consider, as Representative Birch proposed, further legislation. But I do believe that there are significant actions that can be considered quickly. And so finally, to your point about why wait, I think it is clear in conversations and frankly, even in the hearing we had, that while there is support for this, there is not agreement on precisely what actions are most appropriate. And that's why it makes sense to have this body make that report so that we can decide on what steps to take. Do I believe that there will be an immediate influx of new revenue? Absolutely not. I believe it's something that happens over time, and that's one of the considerations that the Commission would need to take account of.
Yes, Representative Horgan.
This mentions Delaware corporate law, and it is true that there's many corporations that otherwise have no particular connection to Delaware who are registered in Delaware, and that's something that especially Delaware has developed over, like, I think, over a century for a very long time. So I'm not sure how realistic it is, how much of the action that I'm not sure how much of like the activity that's going on in Delaware will like transfer here to New Hampshire just if we pass a law that's kind of similar to Delaware's. And of course, I suppose it's not relevant to point out that Delaware is home of a certain former president who A, ran as a write-in in the New Hampshire primary, and B, is the only president whose portrait is not on the wall of fame that was recently installed at the White House. But anyway, so I just don't see much point. I'm not exactly sold on like what this commission is going to accomplish. I mean, certainly it'd be a long time before we can like get much work and cut in on the action that Delaware is getting. And I'm not sure that even that Delaware is necessarily, any richer than we are. So I'm not sure whether their economy is necessarily that much better or worse than ours is. So thanks.
Anyone else wish to be heard? All right, so the vote is on, right now is on the amendment 2026-0897H. I'd ask the clerk to call the roll on the amendment.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
On the amendment, right.
Rep. Horrigan,
Oh, on the amendment, yes.
Rep. Davis,
No.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rung,
No.
Rep. Bergeron.
No.
Chairman Lind,
Yes.
motion passes 13-4.
So we're now on to the main motion of OTPA. You so move, Representative McFarland?
I do.
All right, is there a second?
I second.
All right, moved by Representative McFarland, seconded by Representative Kutab, on the main motion of OTPA. Anyone else wish to be heard? Yeah, Representative Ron.
Thank you, Mr. Chair. I'm going to be voting against this, and primarily it's for practicality purposes. I've been serving on the PFAS Commission for now, I think it's 7 years. And we had a real urgency setting up that commission to deal with the environmental health impacts from the Saint-Gobain PFAS contamination of our water and our soil. And we brought many great bills forward, one which this committee ITL'd today. But one of the things I've learned from that commission is that it can be very onerous dealing with the number of people, even going to 2 senators. It's very rare that we have 1 senator at our meeting. It's very onerous to get people to take notes and writing the report. And had we, I still think the commission is very important. Obviously, we meet every month, but I'm going to vote against this because I think the desired outcome from this commission can be better served from a study committee, where some of these experts, subject matter experts, can come in as visitors or contribute without having the responsibility of being part of a quorum and having that commitment, that time commitment. It gives more flexibility and more efficiency and effectiveness than having a commission like this. Thank you.
All right, anyone else wish to be heard? Representative Birch.
Thank you. As I may have indicated, or actually I didn't indicate about this, I'm a bit agnostic about the concept, but I don't think, and I'm paralleling what Representative Rung just said, I don't think this is the right train to run in the second year of a legislative term, with the idea that we change about 1/3 of the membership of the House every 2 years, and that just creates more problems on top of the problems that Representative Smith outlined. So my strong suggestion would be, although it's not on the table, is to bring this back next year, preferably as a study committee, because I've served on commissions and I've served on study committees, and I prefer the study committee. So I'm going to vote against it more because I think the timing of this and the structure of this is wrong, as opposed to ultimately whether the idea is a good idea or not.
Anyone else wish to be heard? Representative Horgan.
I just apologize for the committee. I kind of jumped the gun. I spoke against, in favor, I was like thinking ITL, and of course I spoke with lengthening the amendment, which I ended up voting for because the amendment was it was harmless enough and actually at least set a deadline for this commission to submit a report. But I think the idea probably doesn't deserve a commission. I think it's fairly unrealistic. I mean, it's certainly not it's not a terrible thing to think about. Maybe I just have very severe doubts that we're ever going to get we're ever going to get much. We're never going to get much of the action that Delaware has been getting from all the other states from hosting corporations. I just have severe doubts about whether we can do a better job of doing what Delaware is doing. So that's why I'm also voting for the ITL, and I probably should have saved that comment for now instead of making it earlier. So thanks.
Anyone else wish to be heard? All right, so the motion before us is OTPA on House Bill 1419, and I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
Oh,
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rung,
No.
Rep. Bergeron,
No.
Chairman Lind.
Yes.
Motion passes 9-8.
All right. All right, Representative McFarland, you draw the honors for writing the majority report.
Would it?
Who will write the minority? All right,
Sure.
and that'll be, I assume, ITL? Okay. All right, I'm going to close the hearing, the executive session on House Bill 1419. I'm going to open the executive session on House Bill 1593, and the chair recognizes Representative McFarland for a motion.
I move ITL, Mr. Chairman.
Is there a second?
I second the motion.
All right, moved by Representative McFarland, seconded by Representative Andrus. Representative McFarland, do you wish to speak to your motion?
I think we covered this in the hearing, Mr. Chairman.
All right, anyone else wish to be heard? Representative Horgan. 1593, yeah. Representative Horgan.
or should I do any other? I can defer to another member of the caucus who wants to speak. But I just want to say this bill codifies something called Section 504. That was the first Federal Disabilities Rights Act law. So that was passed almost half century ago. It was followed by IDEA, which is the Individual Disabilities Education Act, and of course, what we're really famous with, ADA, American Disabilities Act. So it's helped differently abled granted status to access education, healthcare, housing, employment, public service on an equal basis with everyone else, which we've done a very good job of doing. But I think I just think there's a lot of value to like codify it in the state law. So where there's disputes over these issues, they can be dealt with in state courts, and also we're perhaps somewhat less reliant on the federal government. The current administration has a somewhat different philosophy about how disabilities rights and previous administrations have, and I'll also point out like almost 1 in 8 granted staters officially has a disability, according to a very conservative estimate made by the UNH Institute of Disabilities in conjunction with the Census Bureau, which does the American Community Survey. So that's 13.2%. That's 1 out of 8. If you include, and that's the disability. That's something we can all become disabled at any time. We're just one illness or one accident away from becoming disabled. So I think this bill. I think this bill is well worth it. There may be some costs to it, but the benefits vastly outweigh it, especially since all it's about is enabling everyone to fully participate in everything that goes on in New Hampshire, including participating in the economy, both as workers and as consumers. So I would just urge you to. This bill's long overdue. I think now is the time to pass it. So I certainly would urge everyone to vote no on the ITL and then OTP on the bill as introduced. So
All right, anyone else wish to be heard? Yes, Representative Smith.
Yes, I guess I'd like to take, I'd like to take issue with what my fellow Durham colleague just said, in that any one of us is just an accident or an incident away from being handicapped. You all know that certainly is true for me. But that is totally irrelevant because it has nothing to do with whether you or I are unable to participate fully in the way we would like to. This has to do with everyone and everyone else. And it is a question of our level of decency, our acknowledgement that just because someone has a handicap does not mean that we should treat that individual in a way that doesn't make it possible for him or her to fulfill their full role as responsible participatory citizens in this country. The question of taking into state law something that is in federal law is worthy of discussion. States, we have 50 states, and the states do things in a different way. And sometimes, depending upon whose ox is being gored, we might say, well, yes, we want to use the federal, and other times we want to use the state. And each of us has been on different sides of that issue, and it's complicated. But what we're talking about here is that because we have had for many years, actually historically led by not the party that I participate in, but the other party, we have had at the federal level very strong protections, particularly for people who want to get further education, people who want to get vocational training, people who want to have an opportunity to have jobs so that they can earn some money and contribute to the economy of their family and of the state. Those have always been protected by the federal law. We in this state should count on that. We should be willing to stand up and say, we as a state, just as we did with IDEA, just as we've done with the ADA, we should say, we want to be fully recognized as honoring every one of the people in this state, whether they're walking with a walker or using a hearing aid or having any kind of disability. When those individuals say to us, we want to be educated, we want to be trained, we want to be employed, we want to contribute to the well-being of the state of New Hampshire. And by putting 504 into our state law, that's what we're doing. In terms of cost, that's never a problem in this state because if we don't feel like paying for it, we don't. And we've demonstrated that in a dozen different ways, not just education, but in lots of different ways. What this is doing is saying we honor all of our citizens. And for those of us who are old enough to remember times when we weren't willing to honor all citizens, I would like to use a phrase of a very distinguished Boston lawyer who said in a different environment, but nonetheless appropriate, who said, have you no decency? It would be decent for us to honor the needs of people who need a little help. And that is, in fact, why from the very beginning we've had government. We've had government to make it possible to do things that individuals couldn't do on their own. So I plead with you not to vote ITL, but instead to support this very modest legislation. Thank you.
Yes, we can break for 2 minutes. We'll take a recess for 2 minutes.
I don't believe it. It's so hard for me to.
Sure, you want to have a, all right, so, yeah, can I ask the members of my party to? All right. All right, so the Judiciary Committee is back in order. I believe that we have before us an outstanding motion of ITL on House Bill 1593, moved by Representative McFarland, seconded by Representative Andrus. Anybody else wish to be heard? Yes, Representative Birch.
Thank you, Mr. Chair. I'm reminded as I was driving in today, I was listening to a mixtape, and one of the songs was by Bruce Springsteen, where the line was, now I'm having a hard time remembering it, but if you fall behind, I shall wait for you. I'm, to tell you the truth, somewhat saddened by the discussion and what I understand the positions are on HB 1593. I frankly think that we would hope that this committee would unanimously support the bill, which clearly is not going to happen. I'm going to speak personally for a moment. We've heard reference in the past, so I'll just speak as to myself. I'm a person of faith. Faith informs much of what I do. Probably should inform more, but it informs a fair amount. In my faith community, the idea that we're all God's children is an important concept. And I think that's true in most faith communities. And I can't help but visualize the folks from the disability community that came in and testified before us. And I almost see the seats being filled with them as we discuss this bill. This bill is a small ask. It is a very, very small ask. It doesn't ask for brand new legislation. As we know, it's more or less covered by federal law, though perhaps in a diminishing sort of way. We're not asking, the disability community here is not asking to spend money. Fiscal note has kind of a zero on it. This bill does not create new rights. This bill simply assures that we don't leave behind those that are not capable of keeping up with us at all times. And in some respects, I don't see it any different than stopping by the road as a Granite Stater when somebody's broken down and giving them a hand. That's what we do as Granite Staters. And maybe the proper reference is not particularly for my faith community, but from an adjoining faith community that says, and this isn't a direct quote from Matthew, but it's pretty close, as we treat others, as we treat the least of us, that is how we should be judged. And I think that's true, whether that's a variant on the golden rule, which is kind of universal. Do unto others as you would have others do unto you. There is no reason that I can see why we should put boulders in front of those whose walking is so hard as it is already. And I can understand the theoretical arguments, and I can understand the legislative arguments, and I've made them and I've heard them and the like. But at some point, these are members of our community. They are our neighbors. They are our children. They are ourselves. They are people we don't know but are serve us at box stores or at restaurants. And all they came in to do was say, make sure that we have the kind of protections we need to be as fully functional members of our society as we can be. And I just simply do not see a reason not to support a bill that just does that, doesn't create or spend more. It simply says, yeah, we're going to make sure in this state that the road in front of you doesn't have unnecessary boulders. And I just want to ask everybody to take a step back and think, is it really necessary to kill this bill? And thank you.
Chair recognizes Representative Mann.
Thank you, Mr. Chair. I wasn't going to speak on this bill, but, well, I'm being made right now to feel like if I vote against this bill, I'm voting against people with disabilities, and that I have no compassion, and that's the reason why I would vote that way for it. How dare I? I take offense to that. I have a daughter with disability. And for somebody to say that I don't have compassion because I vote for a bill that has problems, there are a lot of problems with this bill. And I take offense to people labeling me as not being compassionate because I vote to ITL it.
Anyone else who should be heard? Yes, Representative McFarland.
Thank you, Mr. Chairman. Similarly, I was, as I said at the beginning with the motion, not going to say anything, but I think it's important. Do unto others as you would have them do unto you is a Christian sentiment, and it's a sentiment that I wholeheartedly support. We could argue the toss on whether we should also compel others to do to you as you would have them, do to you. And that's not what's at issue here. As my honourable colleague said, what's at issue here is we have a bill before us that does, in fact, expand things. You said that it creates no new category of protected class, and you're right. But it absolutely creates new causes of actions. It creates new enforcement authorities. It creates very broad rulemaking authorities. It is in and of itself, in its language, broader than the federal language. And it creates, a bunch of new litigation exposures as a result. And I think that this bill is a solution looking for a problem. We have federal protections. Those disability protections already exist. And what this bill creates is simply a new state framework that goes well beyond that and may have a raft of unexpected consequences over and above the consequences, the negative consequences that were already discussed and outlined in the hearing. So for those reasons, I will be supporting the motion that I made earlier.
Representative Tur.
Yeah, thank you, Mr. Chair. Well, first of all, to the last couple of speakers, I hope none of this discussion reflects personally on anyone's vote versus the way that they see the world. I just wanted to, I guess, raise up something that I noticed when we had the hearing on this bill that I thought presented sort of a beautiful, maybe ironic thing, which was it was the end of a very long day of hearings, and Mr. Chair, you were imposing very strict time limits on the speakers, which I greatly appreciate. Even people who had a lot of maybe content to provide. But at the end of this hearing, there were a couple of people who clearly had struggles with speaking, but still stood up to the microphone. And I just wanted to observe that I noticed that you allowed them to continue past the end of the 2-minute time limit. And I thought that was slightly ironic but beautiful that in that very moment when we're hearing about this particular bill, the need to give those folks just a little bit extra time was a very local and personal version of what I thought we were talking about. Thanks.
Anyone else wish to be heard? Yes, Representative Smith.
Thank you, Mr. Chair. First of all, to my companion on my left, at least in terms of seating, I apologize if in any way what I said was to indicate that you or any one of my colleagues was not sensitive to the problems raised by the disability community. My comments were intended to show, and perhaps I didn't do it well, and for that I genuinely do apologize, that if you think about it, sometimes our actions aren't quite understood. I wonder if it might be possible for the chair to continue on the pending motion, which is ITL. And if that motion were to fail, if we would make the next motion be not to pass, but instead be interim study. And that would, I hope on this bill, give us some time to say, I know Representative McFarland alluded to problems in the bill. Let's look at those problems and see if we could address them in some way that is satisfactory to bring about, in the end, a majority position of OTPA. And if there seemed to be agreement for that, perhaps we could find a way to get to yes. Thank you.
Anyone else wish to be heard? So I guess what I'd like to, I'm sorry, somebody else? Yes, Representative Ball.
Thank you, Chairman Lynn. And Representative Smith, thank you for what you just said. I'm in full agreement with Representative Smith. Coming from the education field and working in special education, that is always where my mind is. So as soon as I hear 504 and I hear that, I immediately go to the education scenarios. I have questions as to how making this a state law is going to impact the education system financially. It seems to provide another means over and above going through the special education process, whether it's the ADA or, if you have a concern or a complaint, it seems to give another avenue, which, I don't want to deny anyone with a disability what they deserve, having worked so intensely with people with children with disabilities. That is always my first concern. But I really do have questions about whether or not making this a state law would negatively impact our education system, and what we would have to add to our administration to make sure that we're now filing, because now parents, to me, seem like they can now file federally and state. And so now we have two avenues going to try and get to the same result, which is to get the child what they need. But that's a question I have. I don't know if this really answers it. And I'm reluctant for that reason. I would like to have that answered before I can move forward. So I do agree with an interim study.
Anyone else wish to be heard? So I guess what, Representative Birch.
Yeah, I'm listening and paying attention, and I think there's a lot of merit to what the last two speakers had to say. I don't know whether the process can be that we recess this bill for a period of time and see if there can be some progress made to move it forward. Is that in the realm of the possible that people think might be worth doing?
So, well, I guess there's a motion on the floor. I think we have to, at least vote on that, but but I guess the other thing that I would say here is I think that there are, the idea, I mean, we're in the second year of the biennium, the idea that we're going to be able to resolve the problems with this bill, and I think they are numerous, um, within the time that we would have to do that. I think that's just unrealistic. But the more important thing that I would say here is I strongly support the ITL motion here because I think it's really important to kind of consider what is happening. I don't think any of the people that appeared at the hearing who, with the people who appeared with disabilities had, it seemed to me, very significant disabilities of one kind or another. And I'm not aware of any effort at the federal level to sort of undercut, the availability of services or treatment or whatever from them. And it seems to me, the idea that that would ever get through Congress is just it's not, it would never happen. I think what is happening, and I fully support this, is that there are some efforts at the federal level to curtail the abuses of the system. And I think that there are very, very significant abuses. And the problem is not with people that have serious disabilities. There's no question. I have no doubt whatsoever that those people should get full services. But the problem is that it's this whole area of disability has been expanded to such an extent that there now is significant abuse, at least in my view, in the areas of, really sort of very, very minor idiosyncrasies that in past years would have been, fine. This person, it it took a little longer for this person to learn to read. I mean, one of my granddaughters, it took her a little bit longer to be sort of talking and reading and stuff when she was young, but she's now, I mean, she's, getting high honors in school, and I have no doubt that she's going to go on to college and all that kind of thing. I guess all I'm saying is it's those kinds of abuses that I think the federal government is trying to trim, and I think that is something that it's appropriate to do. And I just give you an example of the kind of thing I'm talking about. I remember talking to a former colleague who was in charge of, whose responsibility at the time was monitoring people who were taking the bar exam, and he told me about sort of what appeared to me to be just an unrealistic number of people taking the bar exam who are asking for like extra time, or other kinds of things like that, where there's a real concern about, is this really somebody that has some kind of disability that needs extra time, or is this just somebody milking the system? And I know that person who I'm talking about had real concerns about the same thing. So it's those kind of things, and I think it's, I just gave one example, but there's a lot of that kind of stuff. And to the extent that to the extent that the impetus for this bill is a concern that the federal government might try to do something to curtail that kind of what I would regard as abuse, I think that's a good thing that the federal government is doing. And I don't think it's anything that any of the people that testified here have anything to worry about. So I'm supportive of the ITL motion. I guess if that fails, there'll be another motion. But I think ITL is well justified here. Anyone else wish to be heard? Representative Oregon.
I guess I guess that's the example of people milking the system by getting extra time with the bar exam. I suppose if somebody passes the bar exam who's not a good lawyer, that'll eventually be found out and the person will be unable to find any clients and will leave the profession. So that's probably, so there's a safeguard even if somebody does pass the bar exam. But we all got the written testimony from Louis Esposito. I guess we call him Dr. Louis Esposito because he's a doctor in education. So he actually had several pages of his concerns about how federal enforcement has changed over the last year and a few months, and I think it goes much deeper than just. I mean, anytime you have a program, some people are going to abuse it, but this goes far beyond eliminating waste, fraud, and abuse from it. So there's a lot of very basic things which the federal government has done, regardless of who's the president, which are not really necessarily being done in the same way or to the same extent as the people of the United States have expected them. You know, a lot of protections I think are being eroded that we've taken for granted and that we should apply at the state levels. I think there's a lot. And so anyway, I think that we all got that in our email box, and even though he only got to speak for 2 minutes, he does have a fairly well, it's not that long, but it's like 13 pages and with 2 pages of footnotes. So there's like a lot of data for that. So I still believe this. We just feel it ought to pass and that it's long overdue. And so, you know, most of the accommodations that we started making over the last half century are things that actually benefit everyone anyway, including people who aren't disabled. And I guess also we kind of alluded to the fact that there are more and more students in the education system who are getting special accommodations and there's also more and more people being diagnosed with autism. That's first of all, that's a large case because our diagnostic tools have improved. We've thought of more accommodations for people who have different abilities. So I don't think, I think that's a good thing rather than a bad thing. And I might also add the case of autism. That's one of the few public health problems that's still being addressed. So anyway, I believe, obviously I'm opposed to the ITL, and I certainly believe, I personally believe we should pass the bill as is. And of course, anytime, the concern about lawyers, lawsuits, anytime you guarantee people's rights when their rights are infringed, they're going to turn to the legal system for redress. And that's just a fact of life. And so usually the problem, I think the number of like totally frivolous lawsuits is probably like much less than some people think it is. But there's anytime you give people an avenue to pursue their rights, they are of course going to pursue it. So I think that's probably a good thing to give the state court system more jurisdiction over this than they've had in the past. So I still support ought to pass. So thanks.
Anyone else wish to be heard? Representative Birch, then Representative McFarland.
Thank you, Mr. Chair. To be clear, this bill imposes no costs on the state unless the state is found to be discriminating. The enforcement is a private right of action. No new staff for the state, no new appropriation, no infrastructure. And to address a point made by Representative Horrigan, attorneys' fees are paid only by entities that have violated the law. This is a civil rights bill. We have parallel enforcement of civil rights bills in this state, where there's federal, we have federal and state. An example of that is New Hampshire's Law Against Discrimination, RSA 354A. This is the exact same principle that we already have in enforcing civil rights provisions. I would also note that as we read the newspapers, The federal enforcement system of civil rights is in disarray. The Office of Civil Rights has been reduced to a fraction of what it was in the past. The Administration for Community Living has been dismantled. Fair housing enforcement grants have been terminated. And you go on and on and on. This is not a hypothetical problem. It's not a question of fraud, waste, and abuse. The problem that's being addressed is that the federal government, in its current iteration, has decided that civil rights enforcement is a matter to be defunded. So that's what we're talking about here. It's not a hypothetical problem. And yes, I recognize that this may present some issues, but by and large, we're not imposing different obligations on the state, and we're not costing the state any money. It's a small ask, and I think we should pass the bill.
Representative McFarland.
Thank you, Mr. Chairman. I very much appreciate my honourable colleague's comments, and particularly with reference to the honourable lady colleague from Durham. I would say that, bearing in mind your remarks, Mr. Chairman, I move to withdraw my motion, and I would make a further motion to interim study this bill.
Is there a second for that? Well, who- Yes. Do you withdraw your second? No. All right, so the motion is still on the floor. All right. All right, anyone else wish to be heard? All right, so the motion before us is ITL on House Bill 1593. I'd ask the clerk to call the roll.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
clerk votes no. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
No.
Rep. Birch,
No.
Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. Davis,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rung,
No.
Rep. Bergeron,
No.
Chairman Lind.
Yes.
Motion fails 7-10.
All right, 7-10 fails. All right, is there another motion?
I move IS.
All right, Representative McFarland moves interim study. Is there a second for that? Seconded by Representative Smith. All right, anyone wish to be heard on the motion for interim study? Seeing none, I'd ask the clerk to call the roll. The motion is interim study on House Bill 1593.
Vice Chair Mannion,
Yes.
Rep. Gagne,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
No.
clerk votes yes. Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
Yes.
Rep. Horrigan,
Oh.
Rep. Davis,
No.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rung,
No.
Rep. Bergeron, Chairman Lind.
Yes.
Motion passes 11-6.
6, interim study. All right, so, Representative McFarland, you write the majority report?
Yes.
All right, and who wants to write the minority?
Although I guess my minority report is in favor of ought to pass, so.
Right, I understand.
I don't know.
Uh,
I guess I've already written it up, as you know, so I guess, we can,
uh,
thanks.
All right, so the majority report, will be written by Representative McFarland of interim study. The minority, will be OTP by Representative Horgan. All right. So can I just ask everybody that's, writing reports, can you get the reports to me by 5 o'clock tomorrow? That's Saturday. That should give everybody enough time, it seems to me.
Yep.
What's that? No, come on, 5 o'clock tomorrow, you got enough time. You got the rest of the day today and all day tomorrow.
Oregon's already got his done.
And Oregon's already got his done, that's right. All right, anything else we need to discuss? I just want to thank everybody for your hard work on all of the stuff that we've done so far. I feel like we're in pretty good shape. We're done, and we don't have to have anything next week, except the obviously session. Everybody can maybe relax a little bit, and then we'll start in with the Senate bills, probably the week after that.
And
Hopefully there won't be
And,
hopefully there won't be 70 of them.
no, and if you,
I don't, I'm sorry, I don't.
Yeah.
I think, yes, I think, I mean, I right, oh,
Yeah.
that's right, yeah. I guess, you know what, I'm gonna go over and see Paul on after I leave here and find out like what he's got, where he is on bills and what it looks like and that
Yeah.
kind of thing.
if you, and I guess all of us have friends who serve on the other side of the aisle, even though we don't like to admit it, certainly we should